Want to know one of the absolute easiest ways to lose marks on a company law exam? It's this. A company sends out an offer. They've stamped strictly private and confidential all over it. They think they're safe, right? But in the eyes of the law, and way more importantly in the eyes of the ICAI examiner, they might have just made a huge mistake by illegally issuing a public prospectus. Let's unmask exactly how this trap works.
So let's just get right to it. Is this for real? Could a document that's been so carefully labeled to look private actually be treated as a public offer and unleash all sorts of legal trouble the company never saw coming? The answer is a huge, resounding yes. And understanding the why and the how is absolutely critical if you want to crack the case studies in this chapter.
Okay, let's make this real with a classic exam-style problem. A company needs to raise some cash. They find a very specific group, say 3,000 members of various gas companies, and they email them a share offer. They're super clear in the email, for private circulation only. So what do you think? Did they play it smart and navigate the rules, or did they just accidentally step on a landmine and trigger the rules for a public issue? By the time we're done here, you'll be able to break this down and write a perfect mark-scoring answer. Okay, let's dive right in. Our story starts with Section 23, which is the foundation for everything. It lays out the basic ways a company can raise money by issuing securities. Get this section right, and the rest of the chapter falls into place.
So if you're a public company, Section 23, subsection 1 gives you 4 options. First, the one everyone knows, a public offer using a prospectus. Second, you can do a private placement, which is a more selective offer. And third and fourth are for your existing shareholders. You can do a rights issue, where they get the first right to buy more shares, or a bonus issue, which are basically free shares. You have to have these 4 methods down cold.
Now, pay attention here. When the law says public offer, it's not just a general term. It specifically means an IPO, an FPO, or an OFS. That's an offer for sale. You've got to commit these 3 to memory. I'm telling you, ICAI loves to test the difference, and you can lose easy marks just by mixing up this basic terminology. Knowing which is which can make or break your answer in a case study.
Now let's compare that to a private company. Under Section 23, subsection 2, their playbook is a lot smaller. They can do a rights issue or a bonus issue for their existing members, and yep, they can also do a private placement. But, and this is the absolute soul of what makes a private company private, they are strictly 100% forbidden from making any offer to the public. This rule is everything.
And this little table just sums it all up perfectly. It's your best friend for a quick revision. Public offer? Clear yes for public companies, a hard no for private ones. Everything else? Private placement, rights, bonus? Both can do it. So when you get a case study, the very first thing you need to figure out is what type of company you're dealing with. Because as you can see, that one tiny fact changes the entire game.
We keep throwing around this word securities, so let's quickly define it. Section 2, Clause 81, tells us what it is. And the big takeaway is that this term is incredibly broad. It's not just shares. It's stocks, bonds, debentures, derivatives, units from a collective investment scheme. The list just goes on and on. For your exam, just remember the scope is massive.
Now, here's where it gets interesting. You need to know what's specifically not included. The law explicitly says the definition of securities excludes any unit-linked insurance policy, a ULIP. This is a classic MCQ trap. ICAI will give you a list of 4 things and ask which one isn't a security. And the answer is almost always the ULIP. Don't fall for it.
You know, the law is always changing to keep up with business. And a really key recent development, something ICAI loves to test, is in subsections 3 and 4 of Section 23. This is a new route that now allows certain types of public companies to directly issue and list their securities on foreign stock exchanges. It's a huge deal, a business-friendly move to help Indian companies get global capital more easily.
All right, let's move to our next section and see how this all connects. We're shifting gears now from how companies issue securities to who regulates them, and then we'll get to the definition that this whole chapter is built around, the prospectus.
Okay, a huge point of confusion for students is always who's in charge. Is it SEBI? Is it the central government? Well, Section 24 makes it pretty simple. Just think of it like this. If a company is listed or is about to be listed, SEBI is the boss for anything related to issuing shares, transferring them, or not paying dividends. For pretty much everything else in listed companies, and for all matters with unlisted companies, the power is with the central government, the tribunal, or the registrar. Getting this distinction right is vital for case studies.
And now, the star of the show, the prospectus, defined in Section 2, Clause 70. It starts off simple enough. A prospectus is any document described or issued as a prospectus. Now that right there tells you something important. The law cares about what you do with a document, not just what you call it. But that's just the tip of the iceberg.
You see, the full definition has 4 parts. First, any document you actually call a prospectus. That's easy. Second and third are special types, a shelf prospectus and a red herring prospectus. But that fourth one, that's the sneaky one. It includes any other document, a notice, a circular, an ad, that invites offers from the public. This fourth piece is the open door to the trap we're about to discuss.
Which brings us to the climax of our whole discussion, the deemed prospectus trap, which is all laid out in Section 25. This is where ICAI loves to set its trickiest questions. It's a bit of a brain twister, which makes it highly examinable. So let's really focus here.
So what is this trap? Well, Section 25, subsection 1 is smart. It says if a company allots its securities to an intermediary, like an investment bank, knowing that the bank is just going to turn around and sell them to the public, the law closes that loophole. It says the document the bank uses to sell the shares is deemed to be a prospectus from the company itself. The company can't just hide behind a middleman to get out of its legal responsibilities.
But you might be thinking, how does the law prove the company had this plan? Well, it uses 2 powerful automatic triggers. The first trigger is time. If that offer to the public by the middleman happens within 6 months of the company first giving them the securities, the law automatically presumes the whole thing was a prearranged plan. The burden of proof is now on the company to prove it wasn't.
The second trigger is money. If, on the day the public offer is made, the company still hasn't received the full payment for the securities from that middleman, the law again presumes it's a deemed prospectus. The logic is simple. If it was a real sale, they would have been paid in full. Incomplete payment looks a lot more like a commission deal. If just one of these 2 conditions is met, the 6 months or the incomplete payment, that's it. It's a deemed prospectus. This is exactly where people lose marks. And if a document gets caught in this trap and is deemed a prospectus, it has to look and act like one. It needs all the usual information from Section 26, plus a few extras. It has to state the net amount of money the company actually received so everyone can see the middleman's profit. It has to list the time and place where the contract can be inspected for transparency, and it must be signed by at least 2 directors to make sure the company is held responsible. So, we've set the trap. But you've probably noticed that this whole thing hangs on 2 simple words, public and issue. What do those words legally mean? Let's decode them using some major case laws that ICAI absolutely expects you to know and quote in your answers.
First up, what exactly is the public? Does it mean literally everyone in the country? Or can a small, carefully chosen group also count as the public? This question is the absolute heart of that exam problem we started with.
Well, the famous case of Re South of England Natural Gas Company gives us the clear answer. The court said that public includes any section of the public. It does not matter how you selected that section. So let's go back to our 3,000 gas company members. Are they a section of the public? You bet they are. It doesn't matter that they're all from one industry. The key is they aren't existing members or employees of the company making the offer. Therefore, the offer was made to the public. Simple as that.
Now for the second critical question. What does it mean to issue a document? If I write up an offer and only show it to my friend in a private chat, have I legally issued it to the public?
For this, the case of Nash versus Lind provides the perfect contrast. The court said that for a document to be issued, there has to be some level of publicity. The offer needs to be available to more people than just the one person it was sent to. A truly private one-on-one communication, meant only for that single person, is not an issue. The key difference is publicity versus pure privacy.
So, picture this. An investor gets burned because of a misleading prospectus and decides to sue one of the directors. The director's big defense? Hey, don't blame me. I just trusted what the promoters told me. So, what do you think? Is that a good enough excuse to get him off the hook? And the answer is a big, fat no. He is absolutely liable. Blindly relying on promoters is not a defense the law accepts. This is exactly the kind of practical question ICAI loves to throw at you. You see, the law holds directors to a much, much higher standard. So let's break down the why so you can nail the perfect answer every single time. All right, first things first, let's talk about the core problem. When the law says a prospectus is misleading, what does that actually mean? So this is super important. Section 34 tells us a misstatement can happen in two ways. First, if a statement is misleading because of how it's presented. And second, and this is the real kicker, if you leave something out and that omission is likely to mislead someone. It all comes down to this legal principle, uberrima fides, which basically means utmost good faith. A prospectus isn't a sales brochure. It's a legal document where you have to lay all your cards on the table, good and bad. And the perfect example of this is the landmark case Rex v. Kylesent. The company's prospectus proudly announced that they had been paying dividends for years. And hey, that was technically true. The problem? They conveniently forgot to mention the company was actually losing money, and those dividends were being paid out of reserves, not actual profits. The court said, nope, that's misleading. The big takeaway here? A half-truth designed to create a false impression is treated as a complete lie by the law. Okay, but what if a statement is just kind of vague? Well, in Henderson versus Lacan, the prospectus claimed a large portion of the capital was bought by the directors. Sounds good, right? Gives you confidence. But in reality, they'd only bought 10 shares each. The court found this was misleading because it painted a picture of strong insider confidence that was totally fake. And here's another favorite IKI trap, ambiguity. In Smith v. Chadwick, the prospectus used a phrase that can mean two things, one true and one false. The court's logic was simple. If you're a director and you intentionally use a statement that you know could be misinterpreted in a misleading way, then you are, in fact, misleading people. You can't hide behind clever wording. So now we know what a misleading statement looks like. Let's move on to the consequences. If you're an investor and you've been duped by a prospectus, what are your options? What can you actually do to fight back? An investor has a few different paths for justice, but it's crucial to know who you're going after. You can sue the company itself to either cancel the contract or claim damages, or you can go after the individuals, the directors, promoters, experts, for compensation or even push for criminal charges. But, and this is a key exam point, guys, these are usually alternative remedies. You can't just claim everything all at once. Now, let's talk about rescission, because it's a big deal. It means the investor can basically say, this contract is canceled, return their shares, and get a full refund with interest. But, and you gotta pay close attention here, this is where marks are easily lost, there are two major exceptions. This right is only for the original allottee, the person who bought the shares directly from the company based on that prospectus. If you buy the shares later on the stock market, you're out of luck. Also, the original subscribers to the memorandum can't use this since they're considered founders, not investors who were persuaded by a later document. Okay, let's get into the really serious stuff. The punishment. This is where the law drops the hammer on the people responsible, through civil liability in Section 35 and criminal liability in Section 34. When you look at Section 35, the net they cast is huge. It's not just the company on the hook. Directors, anyone named as a future director, promoters, experts like CAs or valuers, basically anyone who authorized the issue can be held liable. The direct consequence is they have to pay compensation for any loss the investor suffered. And here's the part that should honestly be terrifying for any director. If it's proven that there was an intent to defraud, their liability becomes unlimited and personal. That means their personal assets are on the line. So, is there any way out for these guys? Yes, Section 35 provides a few specific escape routes. You could prove you withdrew your consent before the prospectus went out, or that it was issued without you even knowing, and you immediately put out a public notice as soon as you found out. You could also argue that you were relying on a competent expert's report. And finally, the big one that brings us back to our first question, you can argue you had reasonable grounds to believe the statement was true. Just saying the promoters told me so, that's not a reasonable ground. Okay, pop quiz time. Let's test this out. An expert, let's call him Annie Lush, is horrified to see his name attached to a prospectus full of misstatements. He immediately puts out a public notice saying it was all done without his consent. Is he in the clear? And the answer is yes, absolutely. Annie Lush is safe. Why? Because he used one of the specific defenses laid out in Section 35, subsection 2. By taking immediate and public action, he successfully proved the document was issued without his knowledge or consent. And that's enough to escape liability. It just shows how critical it is to act fast. Now listen up, because ICAI loves to test the difference between Section 34, which is criminal, and Section 35, which is civil. The main thing to remember is that Section 34 is about punishment for the act of fraud itself. Section 35 is about making the investor whole by paying compensation. And here is an absolutely critical distinction for your exams. For criminal liability under Section 34, it doesn't matter if the investor actually lost money. The crime is the act itself. But for civil liability under Section 35, the investor has to prove they suffered a financial loss. Okay, but the law doesn't just stop at the prospectus. Let's move on to the fallout and look at some other related sections that are designed to catch fraudulent behavior in the whole investment process. There are 3 more sections you really need to know. Section 36 is for punishing anyone who tricks someone into investing money with false promises. Section 37 is huge. It allows a whole group of people who've been affected to sue together, which is what opens the door for class action lawsuits. And Section 38 is all about personation. That's applying for shares using fake names or making tons of applications to game the system. And you see the pattern here, right? All of these offenses point to the same massive penalty, Section 447. Which brings us to the final boss of penalties in the Companies Act. Let's talk about the ultimate punishment for fraud under Section 447. The penalties under Section 447 are no joke. We're talking serious jail time, up to 10 years, and fines that can be 3 times the amount of the fraud. But honestly, forget the numbers for a second. The most critical thing you have to remember for your exam is the definition of fraud itself. It includes any act, omission, or concealment with the intent to deceive. And here's the line that trips everyone up: whether or not there's any wrongful gain or wrongful loss. That means you can be found guilty of fraud even if you didn't make a single rupee and even if nobody lost any money. It's the intent to deceive that counts. Don't forget that. All right, we've talked a lot about the punishments for getting it wrong. So let's flip the script and talk about how to do things the right way. This brings us to the actual process and the rules for a valid allotment of securities under Section 39. This is all about the practical stuff. For an allotment to be valid, you have to check a few boxes. First, you need to hit minimum subscription, which SEBI says is 90% of the issue. Second, you have to actually receive the application money. Now, how much? Okay, here's a classic trap. The Companies Act says it must be at least 5% of the nominal value, but SEBI rules, which apply to listed companies, are tougher. They demand at least 25% of the issue price. You need to know both. If you don't hit that 90% subscription within 30 days, you have to refund everything within the next 15 days. And if you're late with those refunds, the directors become personally liable to repay it all, plus a painful 15% per year in interest. So there you have it. From subtle, misleading omissions to the risk of unlimited personal liability and even jail time. It's pretty clear that the law places a massive weight of responsibility on professionals like you will be. Which leaves us with one final thought as you continue your studies. As a future professional, when your name is on a document that thousands of people will put their trust in, where does your primary duty lie? Is it to the client who's paying your fees, or to the public that's relying on your integrity? It's something worth thinking about. That's all for today. Study smart, and I'll catch you in the next one.